Welcome to today's Scott and York webinar, What Does Brexit Mean for IP? We have three speakers to talk about the impacts and consequences of the decision to leave. So I'd like to hand over to Andrew Mackenzie to talk about today's topic.
Thank you very much for joining us. We're going to talk very quickly at the beginning about how the UK might leave the EU, just to set the scene, and then move on to some of the possible structures that might come out of negotiations as the UK exits. Then we're going to move in detail into some of the registered IP rights, starting with patents, and then my colleague Cathy Ayres will look at trademarks, designs and copyright, and then the possible effect on agreements of the UK leaving. And then my colleague Marco Morbidelli will look at an outside UK and EU perspective on how things may turn out. As usual, you'll probably have a text box on the right which you can type questions in. Please do that if there's anything that's unclear. If it's pertinent, we'll take that during the presentation. Otherwise, we'll look at that afterwards. So the mechanism for Brexit, the Treaty of Lisbon introduced a new mechanism, Article 50, which provides 2 years for the UK to negotiate with the European Council to decide on the framework for the future relationship with the EU. Just for reference, the Council is heads of the 28 member states of the EU, plus its own President Donald Tusk and the President of the Commission Jean-Claude Juncker. The decision on the agreement is made by a so-called qualified majority of the Council, and again that was new in the Lisbon Treaty. That was redesigned, and it is a double majority, so it has to have 72% of the Council members, in this particular case of course excluding the UK, and again those Council members have to represent at least 65% of the EU population, again excluding the population of the UK. And of course any agreement is on the other side going to require approval by the UK Parliament. It's a little unclear when Article 50 is going to be triggered at the moment. It hasn't been triggered, and it seems unlikely that the negotiations will take less than 2 years. So the reality is that we would probably be looking towards the end of 2018 before anything changes at all. So in this webinar we're going to be looking at how things might turn out post 2018 and what preparations and so on should be made in the interim. So possible outcomes. The so-called Norwegian option, because this is what Norway has, its relationship, and also Iceland and Liechtenstein, although they're very small territories. Joining of the European Free Trade Area would then allow the UK to rejoin the European Economic Area, and that has very similar rules to the EU. So actually would probably mean not a lot of changes. However, I think it's unlikely that option is going to come out because politically it's going to be very difficult. An absolutely essential part of that sort of deal would be free movement of people, which appears to have been a political problem and a big driver for the UK's referendum result. Similarly, the Swiss option, that has perhaps on the face of it a nice compromise in that you can get a custom sort of design of the trade and services relationship between the UK and the EU. However, the Swiss government has had to accept free movement of people as part of that deal, and indeed the reason Switzerland has bilateral treaties instead of being alongside Norway in the EEA is that the Swiss people by referendum rejected the idea of free movement of people. So there's something of a political fudge going on with Switzerland. Several treaty negotiations are completely stalled at the moment, and there's quite a reluctance on the part of the European Council now to continue with any more bilateral treaties with Switzerland. So I think it's unlikely that the European Council is going to want to open up a new set of those sorts of treaties with the UK. But again, potentially that means business as usual if something like that can be achieved. And perhaps in the same vein, the Canadian option, the so-called CETA, single bilateral treaty, but in a lot of ways similar to the relationship Switzerland has with the EU, albeit without free movement of people. So I think negotiating something like that might be a good political compromise, and might work quite well in terms of not too many changes with our relationship, but possibly some good advantages. As many political commentators in the UK have pointed out, however, that took very many years to negotiate. So it's going to be something that would hang over for quite some time. The Turkish option is simply a free trade area, a customs union, mostly deals with goods and not services, probably won't have any sort of recognition of legal rights and so on across the territory, so probably is not really going to change anything in terms of IP, in that the UK would just be a completely separate territory to the EU. And similarly with the World Trade Organization type of agreement, that effectively sets a non-discriminatory regime around goods and services, so would result in some barriers and tariffs, and the level of those really is going to depend on, I suppose, what the UK negotiates with other countries, as the EU historically has very high trade barriers relative to a lot of other countries, so probably the minimum bar on that will be set by the UK's agreements with the other countries. But it's probably going to leave us in a separate sort of UK and EU, two separate territories. So looking at the sort of effects that might come out of those things, one thing that's worth noting is that the European patent system is completely separate from the EU. So in terms of representation for UK IP attorneys, nothing changes. When it comes to trademark and design representation, it's a bit unclear exactly what's going to happen, because it depends what option on that previous slide we negotiate. It's possible that there'll be some need to re-register at EU IPO. We don't know yet. We're looking here at Scotland York about taking steps to make sure that we can continue representation before the EU IPO. That will certainly be possible, but which option we need to use for that will of course depend on what the negotiation is. And we have had some questions over the last week or two about UK systems. It's just worth mentioning for those of you outside the UK that the UK does have a full patent design and trademark system of its own that's been there for many decades, if not 100 years or more, and that is completely unchanged as well, of course. So just looking at patents in detail, there is no change at all. Whatever happens in terms of negotiation, the European patent system, because it's separate from the EU, will continue exactly as it does now. And of course the separate UK system that's already in existence will also continue as before. Assuming no treaties are changed or whatever, and I'll come on to the unitary patent on the next slide, but UK coverage for patents will be achieved exactly as it is now, with a UK designation at the European Patent Office under the existing European system, or a national filing directly at the UK Patent Office. So business as usual on patents. Now what may change, and again it's unclear, is that the unitary patent and unified patent court, so this is the EU sort of patent system, which hasn't started yet, has been on the statute books for a very long time, was expected to start early next year. And really what needs to come into force, if you look at that second bullet point, is the Unified Patent Court, which is the first court of its kind in the EU, covering the whole of the EU and giving pan-EU enforcement. That has to come into force, and then the unitary patent comes in automatically alongside it. Now, the unitary patent is going to be a separate designation on a normal European patent application. So it's a choice for any applicant through the EPO to have a patent that covers the EU. It's worth noting in that, though, that it's not truly a unitary patent. Spain, Poland and Croatia already haven't signed up to that, so it's the EU minus those 3 states. And indeed, Spain and Italy sued the European Commission thinking that the law wasn't brought into force in the right way. So there's some non-unitary nature to that. Italy has since decided they will join up. The UK and France and Germany need to ratify to bring those treaties into force. At the moment, only France has done that. The UK is ready to ratify but hasn't deposited the relevant instruments, and Germany is some way off ratifying. The other requirement to bring that agreement into force is that 13 countries have to ratify, and at present only 10 have. But it's quite close to ratification. Commencement in early 2017 is a distinct possibility, but probably depends on what the UK decides to do. Now, soundings are at the moment that the UK intends to ratify. Also, the preparatory committee that was held just a week after the referendum result, the chairman acknowledged the result but said, well, we will still continue with technical implementation and we will continue with recruitment of staff and judges and so on. And the recruitment completed on the 4th of July, so that's been done. The court buildings in London, Munich and Paris are more or less completed. So the most likely outcome on that probably is that there may be some delay while it's worked out whether the UK will ratify, and perhaps more importantly, what will happen to the Central Court building in London once the UK leaves the EU. At the moment, the agreement appears to be structured that the UK would have to move out of the unitary patent system and the Unified Patent Court, which would appear to mean that the London branch would have to move elsewhere. We just don't know at the moment. There's also some political will to keep the UK in it by a treaty renegotiation. If the London branch closes, then it's again sort of early days, but there is suggestions that might move to Milan or to the Netherlands, to The Hague. Those being the sort of 4th largest users of the system. But again, we don't know. I think the outcome is that there will probably be delay while decisions are made. If renegotiation is required, I think some of the tensions that were under the surface while the treaty was finally agreed may resurface, and it may stop the thing indefinitely. But I'm hoping we'll know more about that in the autumn. Now, for the moment, let's assume that the court comes into being and the UK comes out and the unitary patent comes out. Then what we would be looking at is a situation where UK businesses would have access in exactly the same way as Spain, Croatia and Poland and any other country in the world that's not in the EU. So UK businesses will still be able to get a unitary patent, it just won't cover the UK. So it will be necessary, if you want wide European coverage, you'll either carry on as you do now with lots of national filings, or European filings with designations of all the European states, or perhaps a unitary patent which will cover all of the countries that have signed up to that. And if, for example, you also want Spain and the UK covered, then you would designate those countries separately. So not a huge change from where we are now, really, just with the addition that you can get quite a lot of the European states with one tick box. But with the UK and Spain out of it, there will be some significant territories that will probably require, commercially, you'll want to have some rights there separately outside the unitary patent. So that covers the sort of patent thoughts at the moment. So I'm just going to hand over to Kathy now, to look at some of the trademark design and copyright aspects.
Thanks, Andrew. Yes, I'll be covering IP other than patents. So I'll be looking at brands and trademarks, registered and unregistered design rights, and copyright. And my first slide is on brands, and I want to mention these particularly because it's the accepted term used by marketing professionals. But for trademark lawyers, brands actually comprise a number of different things. They can comprise a name or a logo, colours, maybe a particular style of packaging or a style of product. Some of these are more protectable for an IP lawyer than for others. But basically, copyright, trademarks and designs are all relevant here, and they're all going to be affected by Brexit. However, it's important not to get too run away with all the changes that Brexit is going to bring, because the message is really keep calm and carry on. A lot of things won't change. The EU and national systems have always coexisted. The UK registration process is one of the easiest in the world. You've got no power of attorney requirement, no certified copy requirements for convention priority applications, no substantive relative grounds examination, a very reasonable examination process on other grounds, and typically it takes 3 months to get trademark registration nowadays, which compares extremely favourably with the 4 years it took when I joined the profession back in 1990. The UK IPO is incredibly well respected worldwide. They usually examine trademark applications within 20 days, and although I guess there's a general feeling that the opposition process could be improved, it's very good, I think, in terms of the complexity of the issues which come up, and also I think they provide a far superior service to that provided by the EU IPO. It's also important to recognise that a lot of clients have dual protection already, and you may wonder why that comes about. Well, there's a number of reasons. So the first reason is historic. The fact is the EU trademark system has only been in existence since 1996, and so there are plenty of older brands out there which have been registered in the UK and in other EU countries for years and years and years, and will continue to do so. There's also sometimes a bit of indecision around where to register when a client comes to you with a new trademark. So in that situation, typically what we do is we file in the UK first, and within the 6-month convention term, we look to decide where the client might want to get registration overseas. Sometimes, when the convention period is about to expire, the decision is, in fact, that they only intend to use this brand in a few European Union territories, and so it ends up being only a European Union application that's filed, and that then coexists alongside the UK right. The third option, which is also really common, is that many clients file in the UK first with an aim to using the Madrid Protocol system later on down the line. When we use the Madrid Protocol system, we always try to use a UK trademark as the foundation and not an EU trademark because of the central attack provisions. So first of all, a bit of an explanation about what central attack is. The fact is that for the first 5 years of its life, the Madrid Protocol registration is dependent upon its foundation registration. So that's either a UK or an EU registration if you're a UK company. So why is the UK registration better? It's less vulnerable. It's registered more quickly. Typically you'll get a registration in 3 months as opposed to the 6 months or so when it's for an EU trademark or even longer. It's also less likely to be open to cancellation on absolute grounds because I believe the quality control at the UK IPO is better on this. And also with respect to relative grounds, we have to bear in mind that an EU trademark has got national registers in 28 member states to be worried about, as well as the EU register itself. So on relative grounds, an EU trademark registration is much more vulnerable. So what's going to happen in relation to EU trademarks? Well, I think the likelihood is that post-Exit, they will no longer cover the UK. There is some lobbying in the profession, which is why I put or will they on the slide, to try and keep the status quo, but I have to question whether this is realistic. In terms of what might happen to those EU trademarks and whether they're going to continue to cover the UK in future by some mechanism, you'll probably be aware that there's already a conversion process in place before the EU IPO, which allows you to convert an EU trademark application or registration into national rights. However, there's a number of drawbacks with this system. First of all, it's a system which only kicks in once an EU trademark no longer exists. And of course, in our scenario, the EU trademark will still exist. There's also the question of two sets of costs, because you have to pay a fee to the EU IPO and you have to pay a fee to the national offices. You also end up with a bundle of applications, not a bundle of registrations, so there's also an issue. I can't see this being the route that's used to convert EU rights into a UK right in the future. What's much more likely to happen, it seems to me, the re-registration process. And I'm old enough to have seen a number of re-registration processes go on through all the countries in Yugoslavia, all the countries in Czechoslovakia and the USSR. And although sometimes it was a bit painful administratively, it happened. The difficulties in those days, when you have no community-authorised trademark registers, was that as well as copying up with a power of attorney and a fee, you also sometimes had to find the original registration certificate, which when you've got maybe a bundle of trademark rights which you've acquired from somebody else, or you've got very old registrations, trying to locate an original piece of paper is a real nightmare. Nowadays, we have computerised registers, which are high quality. There's no need for all that paperwork to be produced. And I think it's quite conceivable that what will happen is that on the day the UK exits the EU, someone clever will have drafted a computer program which automatically renders EU trademarks into EU 27 trademarks, covering the remaining member states, and a UK trademark as well. Of course, that does leave us with possibly a bit of a bloated register here in the UK, in that there may be some trademarks which get re-registered in the UK, which are really not for use here, but that can easily be sorted out on the next renewal. So what do we have to think about from an EU trademark issue point of view? Well, the first thing is in relation to your renewal timing. You can pay renewal fees on an EU trademark 6 months before the actual deadline. It makes sense to pay early, just so that you might have the opportunity to avoid paying twice. The issue of non-use, trademarks in the UK and in the EU become vulnerable to cancellation on the grounds of non-use if they're not used for a continuous period of 5 years or longer. Around non-use, particularly interesting problems emerge. Supposing you're only using your EU trademark in the UK, what happens post-exit? Supposing you're not using it in the UK, it's going to be a bit of a minefield here, something to come out in the wash. Something to start thinking about now, particularly with the first 3 items I've mentioned on point 3 on the slide, are coexistence agreements, licenses and undertakings you may have, basically contractual issues that you've got with third parties. You should be looking at them now to see if there's any perhaps renegotiation needed. I have to say that no one expected the UK to leave the EU. I think it's become clear from the actions of politicians since referendum results that not even the politicians expected us to leave the EU. And so it's quite clear that if negotiations were done with and coexistence agreements and so on signed a year or so ago, those surely will be interpreted as covering the EU plus the UK. I don't think anyone's going to be able to weasel out saying, oh, but the EU now doesn't cover the UK, and so this agreement doesn't apply here. But it's still stuff that needs to be looked at, particularly if your agreements are not under English law. We've got a few customs applications ongoing for clients, and they're very valuable. They're free of official fees, and they enable customs to seize goods at the borders. There's been a lot of work done on the EU-wide customs system, and I can't believe that the UK will just drop out of that overnight, because counterfeit goods are a scourge which everyone's interested in preventing. Perhaps a good thing which will come out of the Brexit issue is that we will actually review properly where we need protection. The EU trademark, because of its relative low cost and its reasonable speed, has become a real knee-jerk response. And I think a lot of people use the system when they don't really need to. Steps that I'd consider going forward are making national UK filings alongside EU filings, potentially, especially for very important trademarks, simply because at the moment we don't know what the re-registration process will look like. Because of the size of the EU register, if there's any kind of formal re-registration process, it's going to be time-consuming for the UK IPO to deal with. And if your trademark is in that queue, it may be a long time before you actually get a re-registration in the UK. It makes sense for those very important brands to have a separate UK national registration in place now. And for a lot of people that won't be burdensome because they'll be using the Madrid Protocol system anyway. For people outside the UK looking to get registration in UK and EU, then do consider using the Madrid Protocol system, and also reconsider the issue of seniority. Seniority was the mechanism whereby national registrations were all going to be allowed to lapse, and their effects would continue through a seniority claim on the EU registration. Letting UK registrations lapse at this point in time seems a bad idea. So no saving on renewal fees there, just for the time being until we know how the system will pan out. I should explain that the title here is not a typographical error. The revisions to the EU trademark system, and which came in on the 23rd of March, which also changed the name of the office to the EU IPO, didn't affect community designs. So community design is still called just that. Similarly to trademarks, they'll probably no longer cover the UK on exit. Conversion is not a beast, it's not a thing which falls within the community design system, so it's not going to be an option here. Again, it seems likely there's going to be some kind of re-registration system. The UK registered design system is really cheap and efficient. It's not as quick as the EU design system, where you typically get a registration within a day. It takes a few weeks, but it is still very user-friendly. It's little used currently by our clients because of the relatively high renewal fees. The renewal fees on UK designs are actually higher than those for EU designs, but those are scheduled to come down in October. So for example, on the fourth renewal of the UK design, the fee is currently £450, but that is scheduled to come down to £140, which is a massive saving and will make the system much more attractive again. So moving on to unregistered design rights now. A bit of a health warning here. Whenever you feel your life needs more complexity, just go and look at unregistered design rights. The qualifying provisions alone make you want to go and lie down in a darkened room. Our UK unregistered design right has been around for a while. It was introduced by our Copyright Designs and Patents Act in 1988. Community unregistered designs came along later through Council Regulation EC 6/2002. Generally speaking, we get about 10 years protection through unregistered design right in the UK and 3 years in the EU. For both species of protection, you must prove copying. It's not an absolute right, but otherwise they are extremely different. For example, a UK unregistered design right covers aspects of shape and configuration. It doesn't cover pattern or ornament, which is covered by an EU design. But because of the short period of protection that EU unregistered design gives you, I do wonder how much practical effect we're going to see. There are lots of questions over this right, which comes into existence 3 years, when the product is first becomes available to the public in the EU and then lasts 3 years from then. So there's lots of questions about, well, if the first publication of the design was in the EU, does that mean that EU design right no longer exists? It's a complete feeding frenzy for lawyers in terms of hypothetical questions. But I have to say, whenever a design matter comes across my desk, the first thing I find out is that, that time's gone by and the EU design right has expired. So I strongly suspect that in practical terms, we're not going to see very much actual, real practical examples of this across our desk. Copyright, our UK copyright, of course, is a very national right. And on the face of it, you'd think it was probably unlikely to be affected by Brexit. But copyright law, like all our laws, is subject to EU influence. What does this mean? I mean, we get EU influence through what are called directives. And they're legislative acts which set out goals that EU countries must achieve. An example of this is the directive which issued a long time ago now, relating to the harmonisation of trademark laws and which paved the way for the EU trademark. It led to our very clunky and very old and unfit for purpose Trademarks Act 1938 being repealed and superseded by our Trademarks Act 1994, which mirrors EU law to a large extent. And sometimes directives can require amendments to the law, and sometimes They can just require that the law is interpreted in a certain way. However, obviously all directives are looked at by parliamentary draftsmen when they hit their desks, and sometimes they take a view that no real amendment to the law is needed, and that the whole issue is going to be dealt with by interpretation. But then sometimes it can become clearer later that a law amendment is actually required. And this is actually the case with respect to the Section 52 of our Copyright Designs and Patents Act. With impeccable timing, the law change on this is supposed to happen on the 28th of July, so basically next week. Section 52 limits the term of protection for articles which have been manufactured industrially. The example which has been bandied about constantly here is the Charles and Ray Eames chairs, now considered sort of design icons. Obviously those items were considered works of artistic craftsmanship, so artistic works, but because they've been exploited, more than 50 copies have been made of them. The protection on them is limited to 25 years, which obviously is a vast reduction from the usual rule, which is author's life plus 70 years. On the 28th of July, this all changes. There's a note about it on our website. It's pretty complicated. But I have to say that it looks like so many companies haven't got their acting gear on this. Because when I was searching yesterday on the internet for Charles and Ray Eames chairs, copies or replicas, there are hundreds of websites, absolutely hundreds of websites out there selling these things. So it's, people are going to have to race a little to get those items sold and off the market before the transitional provisions expire. Perhaps the most important change on Brexit to us has been, I had a quick look to see how many people had applied to register Brexit as a trademark over the last few days, and needless to say, there have been quite a few trademark applications. One which has sort of hit me straight between the eyes is that Allen and Overy LLP have applied to register Brexit law in relation to a wide variety of goods and services, including legal services, of course. We'll be monitoring that application and seeing where that one goes. I'm now going to pass on to my colleague Marco Morbidini to talk about the perspective from outside the UK.
Well, okay. Thanks, Kathy, for handing over to me. I'm going to talk very briefly indeed about what have been so far the reactions to Brexit within the European intellectual property community. So I have undertaken a brief review of some comments that have been posted in the last weeks or months on various IP blogs, journals, websites, whether institutional or not. But generally, I found that, very broadly speaking, the sentiment within the EU can be divided into two main categories, which I think I have quite intuitively represented graphically in this slide. Of those who have shown to be sort of upbeat about Brexit for reasons that we will see in the next slide, and of those who have rather felt a bit disappointed or saddened or generally are worried about the future. So starting from the former category, at least some European Union countries hope to take Brexit as an opportunity to increase their gravitas in the European IP community. Take, for example, the Netherlands or Italy. These two countries are currently in line to be named the third largest filer of European patent applications at the EPO post-Brexit. Now, this could turn out to be an important status because, accordingly, the Netherlands or Italy could find themselves to be essential to the ratification of the unitary patent and unified patent court agreements, which, as we've seen before with Andrew, are European Union agreements, which will bring in due course the unitary patent and unified patent court into existence. These, of course, could have very good returns for the elected country and for all those involved with IP there. Some of you will also be aware, and we've seen it before in this presentation, that London had been designated as a seat of the Court of First Instance of the UBC as part of the Central Division of this court, in addition to the seats of Paris in France and Munich in Germany. In particular, London would have been the UPC hub for hearing cases relating to chemical and biotech subject matter. There are now reports out there that this is now being contended very likely by European Union cities such as The Hague and Milan, with the latter probably a little ahead over the former. There are then those within the EU who believe that Brexit may mean a potential gradual decline for traditionally very successful UK IP professions, such as IP attorneys, solicitors, barristers, and even judges. And this would, of course, be a direct consequence of the UK becoming gradually more isolated from the European Union, and therefore a less relevant market altogether. For example, UK barristers may no longer be allowed in due course to set foot in the European Court of Justice, the ECJ. There are some reports of UK solicitors and barristers thinking of Dublin as the obvious English-speaking safe harbour for continuing their practice before the ECJ. Now, who knows that in the years to come I will see lawyers aiming for dual qualification in the UK and Ireland. Now, of course, as a profession, I'm sure we'll fight hard not to see this happen, but some of our colleagues overseas are clearly seeing this as an opportunity for their business to expand at the expense of ours. Now, I guess that eventually much in this respect will be dictated by whatever the new relationship will be between the UK and the European Union, and we would hope, of course, that the relationship is strong. And with this, I think that we can have a look at the other side of the medal. Obviously with Brexit, the UK will have an opportunity to regain control of its IP legislation. As we've seen before, much of the current intellectual property legislation in the UK comes from the European Union. So it has been said that this is likely to open the floodgates for potential divergence between UK IP law and European Union IP law in the future. Now, this is of course something that will not be received very positively by the business community, since it may mean that there will be more obstacles for the circulation of goods and services across the UK-EU border. And perhaps there is a more worrying aspect to be considered, which is the next bullet point. With Brexit, the UK will likely lose its role in shaping European Union law. Now, consider, for example, that the UK historically contributed quite substantially to shaping the ECJ into what this court currently is. So at the dawn of the EU, the ECJ, then probably known by another name, is reported to have been a court much shaped in the form of a German, or at least a more continental court. It was the influence and the impact of the UK that historically has transformed the court into what we know today. A court that makes substantial use of oral hearings, that is capable of establishing the law of precedent, which is very much in line with British common law. And therefore many EU commentators, in this respect, see Brexit as a bit of a cultural loss. And certainly, personally, as a citizen of the EU, I am and have been shocked to see Britain leave the Union. And with this remark, I've now concluded my brief intervention in this presentation, and I was going to pass back to Andrew for bringing this webinar to an end.
Okay, thank you, Marco. If you have any questions, feel free to type them into the box. I have one here for Cassie. You mentioned that there might be some sort of re-registration system for UK rights, I think on EU trademarks and also design. Do you have any thoughts when that might start to come into being, and what sort of warning right holders might have in order to get that re-registration rolling?
My recollection is that in the re-registration programs which were put in place in the former territories of Yugoslavia and so on, very generous periods were given, typically 6 months or more. I can't see the EU IPO giving, or the UK IPO giving any less than that, and unless they choose to do it simply mechanistically, basically controlling the whole process themselves. But I think what's absolutely clear is we will be given plenty of notice. The UK IPO, as I understand it, are consulting with various people, in fact today, as we're doing this webinar, within the UK profession. And no doubt the UK profession will have very strong views and be very keen to shape the way the system plays out for the benefit of our clients, to make sure that they're not disadvantaged. Realistically, I suspect we'll probably have a timeline of at least a year. We'll probably know what's going to happen. There'll be a certain moment where it becomes clear that something has to be implemented, and we'll be allowed a number of months post then to make any necessary application.
Okay, great. Okay. Well, I think that concludes our webinar today. The webinar has been recorded, and there will be a link available on our website in due course if you want to re-listen to any parts of it. And of course, if you have any further questions, do feel free to get in touch with us, and we'll answer them to the best of our ability, and the state of play with negotiations with the European Council as it is then. Thank you very much.